of a weapon or ammunition by a convicted felon, and that's in Florida. Count 2, possession of a weapon or ammunition by a Florida convicted felon. Count 3 is possession of PVP. Count 4 is grand theft of a firearm. Count 5 is possession of drug paraphernalia. Count 4 is driving while license suspended, first offense. I'm sorry, that wasn't count 4, that was count 6. Count 7 is driving with an expired tag, which has been expired for more than 6 months. Having reviewed the probable cause affidavit, I do find probable cause.
Your Honor, in speaking with Mr. Jenkins regarding count 1 and count 2, he's been here in South Florida his whole life. Financially, he has no money in the bank, no property, he's not working. Financially, he's indigent. However, his ties to the community, he does, all his family is here in South Florida. We'd be asking you to consider reasonable bond for count 1 and 2. Oh.
Nowhere in the probable cause affidavit does it say that the gun was reported stolen, was the serial number ran to say that it was stolen. It was simply found in, I guess it was found in the car. So there would be a small probable cause affidavit as to the grand theft of the firearm.
Your Honor, in the last paragraph, it says a check of the firearm revealed it was listed as stolen by the Sunrise Police Department.
It's early, Judge. I apologize.
Early.
When I read it, it was early. I apologize. I withdraw that argument.
All right, I do find probable cause with all 7 counts, and bond is set as follows. Count 1, $4,000. Count 2, $4,000. Count 3, $1,000. Count 4, $1,000. Count 5, $100. Count 6, $100. And he is ROR on count 7.
Thank you, Your Honor. Timothy Moore.
I'm a veteran. And,
He's present, Your Honor.
I'm a veteran. And first charge ever.
Burglary with assault or battery. Count 2 is possession of heroin. I have reviewed the probable cause affidavit. I do find probable cause. Your bond is set as follows. Count 1, $10,000. Count 2, $1,000.
Your Honor, regarding count 1, would you consider lowering the bond on count 1? I know he's 23 years old. This is his first charge ever, Your Honor. He's a veteran. He served our country from 2011 to 2013. He was honorably discharged. He did attend college. He hasn't received his bachelor's yet, Your Honor. Considering that, would you consider a $1,000 bond on count 1?
What's the state's position?
Your Honor, I didn't see any priors in Florida. I couldn't see any, or in Broward, I couldn't see anywhere else. But the victim in this case was a 66-year-old owner of the home that he did push as he was trying to flee from the scene. So I would agree with Your Honors.
Also, Your Honor, if I may bring the court's attention, his co-defendant yesterday, Louis Cruzen, there was no PC found by Judge Marks as the same probable cause affidavit. I would be reviewing the probable cause arguments as to the first well. Nowhere in the probable cause affidavit does it say that there was a crime with an intent to commit a crime therein. Like I said, Judge Marks found no PC, gave 24 hours to the evidence. I found the 2500 on his co-defendant, Louis Cruzen. So we would ask the exact same one from yesterday's. The argument, like I said, was that they are just seeing the It's actually a trespass with battery.
You are correct. With regards to count 1, I'm giving the state 24 hours to perfect.
Mm-hmm. Your Honor, if I may respond to the argument. In terms of yes, this is the co-defendant from yesterday, which Judge Marks did give us 24 hours to perfect. I made contact with the detective and there were no additional facts to add to the probable cause affidavit. However, the distinction in this versus the co-defendant is that this defendant is the one who, upon being confronted by the victim, pushed him. It's the state's position that those actions constitute consciousness of guilt and that you can imply his intent to commit the theft therein. He was within the curtilage of the home and it was an enclosed area. Upon being confronted by the defendant or by the owner of the home, he did push that owner, who is a person 65 or older, which is, I believe, a third-degree misdemeanor, which is not listed, but that's beside the point. Additionally, third-degree felony, not misdemeanor. Additionally, Judge Marks set the co-defendant's bond at $22,500. So I think anything less than that would be.
At 2,500.
Yeah, what'd I say? 2,500. No, I said 2,500. I think. Not 22,000. That's not what I meant.
Okay, with regards to count 1, I'm giving the state 24 hours to perfect. And with regards to count 2, I'm setting bond at $1,000. No, that's, I'm giving the state 24 hours to perfect, and, well, no, you have to perfect. That bond is set at $5,000. Okay, David Johnson.
Thank you. Okay. No.
Mr. Johnson?
Yes.
Sir, you are before the court charged with 5 counts. Count 1 is, well, 3 of them are capiouses and 2 of them are violation of probation. I'll go through each one. 1, it's a capious on a grand theft. Count 2, it's a capious on an uttering a forged instrument. Count 3, it's a violation of probation, grand theft, uttering a forged instrument. Count 4, delivery, possession of a controlled substance. Just to an inmate. And count 5 is okay.
Yeah, I think it's an
with
imitation.
regards to count 1, well, with regards to all the counts, I'm looking at a,
Everybody gets blamed for that shit.
I'm looking at a habeas, I'm looking at a warrant signed by Judge Tobin Singer, I'm finding no bond. You're to be brought before Judge Tobin Singer. If I didn't say it before, I do find probable cause.
Okay, you're done. Corey Johns. Mr. Johns.
Mr. Johnson, you're before the court on one count of charges PVP. I reviewed the probable cause affidavit. I do find probable cause. Your bond is set at $1,000. David Mayo.
Mr. Mayo.
Mr. Mayo, you are before the court charged with one count of possession of PVP. I have reviewed the probable cause affidavit. I do find probable cause. Your bond is set at $1,000. Timothy Washington Mayer. Mr. Mayor, you are before the court charged with one count of possession of a controlled substance without a prescription. I have the probable cause affidavit. I do find probable cause. Your bond is set at $1,000.
Your Honor, Mr. Washington is requesting free trial.
I do have faith.
Okay, did you hear that?
No, Your Honor.
Free trial.
Washington is homeless, we have no way of supervising a homeless individual.
Okay.
His bond is set at $1,000.
Thank you, Your Honor.
Dwayne McLean.
Mr. McLean is here present. He did advise me, Your Honor, he does have private counsel. I don't know if his private attorney showed up here.
There has been no one that has shown up. Mr. McLean, you're before the court on 6 counts. Count 1 is possession of cocaine. Count 2 is possession of cannabis, 20 grams or less. Count 3 is possession of a weapon or ammunition by a convicted Florida felon. Count 4 is driving while license suspended as a habitual. Count 5 is burglary with assault or battery. And count 6 is tampering, third count is tampering.
Burglary.
With regards to
Count 5 is what?
Burglary, number 5 is burglary.
Where that come from?
with regard,
When you talk to your attorney, he'll explain it to you.
yeah, what we have is, we've got the
Burglary
probable
was
cause
a warrant.
affidavit, and then we've got, and then at least I have, a warrant on the burglary, of a conveyance with assault, and I've got, another warrant. to
Burglary
assault
what?
tampering. So, I do find probable cause with all 6 counts. Your bond is set as follows. Count 1, $1,000. Count 2, $100. Count 3. $2,500. Count 4, $750. And counts 5 and 6, your bond is set on each count at $50,000. Thank you.
Wait, down.
Raul?
You speak English? Yeah. Okay. VOP, you're going to be senior judge June 10th, 8:30.
General Wicked, that's court, I live court day.
No, not VOP.
I do find probable cause on both counts, and you are to be held no bond.
Thank you. Alfred Igles?
Igles. Mr. Igles, you're before the court on a violation of probation. I have before me a warrant signed by Judge McCarthy. I do find probable cause, and you are to be held no bond until you go before Judge McCarthy. Julio de Leon.
Hold it. Speak Spanish?
Your Honor, we need a Spanish and, oh, you speak English? Okay. Sorry.
Okay, all right, Mr. De Leon, you're before the court charged with 5 counts. Count 1 is possession of alprazolam. Count 2 is operating without a valid driver's license. Count 3 is failing to display the registration on your vehicle. Count 4 is failing to provide proof of liability. Count 5 is failure to use due care. I do find probable cause. Your bond is set as follows. Count 1, $1,000, and count 2, 3, 4, and 5, you are to be released on your own recognizance.
Thank you, Your Honor.
You're welcome. Morley Paul.
Mr. Paul.
Good morning, Mr. Paul. You're before the court charged with 5 counts. Count 1, possession of VP. Count 2, possession of cannabis under 20 grams. Count 3, providing a false identification to a law enforcement officer. Count 4, violating your probation or community control, and that's 2 counts of violation of probation. I have reviewed the probable cause affidavit, and I do find probable cause. I also have before me a warrant on driving while license suspended. Well, actually, that's the underlying charge. I do have a warrant on case number 1310145, which is count 4 and 5. So your bond is set as follows. Having found probable cause, count 1, $1,000. Count 2, $100. Count 3, $100. And you're to be held no bond on count 4 and 5, and you're to be brought before Judge Levinson.
Okay, that's it.
Thank you. Frank, excellent. Mr. Excellent, you're before the court.
Yo, hey, what's up, guys?
You're before the court charged with 3 counts. Count 1 is a capias on a traffic. Count 2 is violation of probation. I do have a capias that was issued with regards to the driving while license suspended on count 1, and I also have an amended warrant. Signed by Judge Houston on the violations of probation. I find probable cause, count 1, bond is issued at, bond is set at $500 on counts 2 and 3. No bond until you are brought before your assigned judge.
Okay, that's it, Mr.
What? Write down my judge. What court date?
Sure.
Thank you very much, sir.
Yes, ma'am.
Get on the phone. Thank you.
Good morning.
You're before the court charged with felony battery resulting in great bodily harm or disability. I have reviewed the probable cause affidavit. I do find probable cause, and we have someone here on behalf of Mr. Armstrong. Could you swear her in?
Oh, that's
Can't hear? I'm hard of hearing.
Okay. Do you solemnly swear or affirm the testimonies you give shall be the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record, please.
Mary Armstrong.
Thank you.
Good morning, ma'am. What would you like to tell me?
That I raised him right. And he has a kind heart. That's what gets him in trouble all the time. He let this lady came in because she didn't have any place to go. He know and he will not touch a woman as to hit her or anything like that. I want you to know that. He finished high school, he finished college, he has a good job, he's with a firm, and he was out there one time, but he turned his life around and he's been sober, no drugs or nothing for quite a few years now, maybe 12 or 13 years. So that's why I'm here to plead for my son.
Your Honor, in speaking with Mr. Armstrong, he's been in South Florida for 50-plus years. He has no money in the bank, no property. However, he is employed. He works at Milton Jones Rental, making $9 an hour. I believe his prior contacts with the system are quite dated, Your Honor. He's turned his life around since then. We'd be asking you to set a reasonable bond.
Okay?
Your Honor, in terms of priors, he had a possession of cocaine in 2005 where he had 2 years probation, and a disorderly in 2004 where he got a adjudication time served. I don't show anything in Broward other than those 2 incidents. We'd be asking for a $5,000 bond.
Your Honor, he's been clean for over 10 years, Your Honor.
Bond is set at $1,500. No contact with the alleged victim.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am.
God bless.
Thank you, Your Honor.
Daniel Tineo.
Mr. Tenale?
Mr. Tineo, you are before the court on 5 counts. Count 1 is possession with intent to sell, manufacture, or deliver cannabis. Count 2 is possession of cannabis over 20 grams. Count 3 is possession of drug paraphernalia. Count 4 is, 4 and 5 are 2 probation violation or community control violations. It looks like it's on 2 separate cases. With regards to, well, I just find probable cause on all 5 counts.
Donaldson, Wayne?
With regards to count 1, bond is set at $1,000. Count 2, bond is set at $1,000. Count 3, bond is set at $100. Bond is set at no bond on counts 4 and 5.
I just came. Yes, ma'am. North Broward.
Mr. Murphy.
All right.
Yes, ma'am. 3 counts. Count 1 is home invasion without a firearm or weapon. Count 2 is battery. Count 3 is wearing a mask or committing a 2nd-degree felony.
Yes, ma'am.
Your bond, I do find probable cause with regards to all 3, and bond is set as follows. Count 1.
Your Honor,
Yes?
regarding Mr. Murphy, the first count.
Your Honor, did you read the
is-
proper cause?
Sir, please do not talk about the facts of the case. Regarding count one, Your Honor, we believe he is entitled to a bond unless the state moves to foreclose bond. In that case, it would trigger a Preston hearing where Your Honor would have to make findings.
I'm trying to set a bond.
Okay, oh, I'm sorry. Thank you, Your Honor.
Okay.
I apologize.
That's okay. Having found probable cause, bond is set as follows. Count one, $10,000. Count two,
Yes, ma'am.
$1,000.
Yes, ma'am.
Count three,
Yes, ma'am.
$10,000.
Yes, ma'am.
All right.
Thank you, Your Honor.
Thank you.
Thank you. Thank you. Thank you. Let's go back. Let's take care of that.
And there should be no contact with the alleged victim. Pierre, Sherry.
Mr. Cherry is here present, Your Honor.
Yes.
Good morning, sir. You are charged
How you doing?
with 3 counts. Count 1 is grand theft of an automobile. Count 2 is possession of alprazolam. Count 3 is possession of cannabis less than 20 grams. I have reviewed the probable cause affidavit. I do find probable cause. Your bond is set as follows. Count 1, $1,000. Count 2, $1,000. Count 3, $100. Thank you.
Can I just say one thing?
James Lawrence.
Mr. Lawrence, how are you?
Mr. Lawrence, you're before the court charged with 5 counts. The first count is aggravated assault with a deadly weapon without intent to kill, and then counts 2, 3, 4, and 5 are all capiases.
Your Honor, I'm speaking with Mr. Lawrence. He's financially indigent. He's been residing in South Florida for the past 25 years. We'd ask you on counts 2, 3, 4, and 5 to release him ROR, considering there's no city prosecutor present, Your Honor, and to appoint counsel. And on count 1, we'd be asking you to set a reasonable bond.
Does Fred have anything they want to say?
Your Honor, in terms of priors, he had, it looks like all misdemeanors in 08, 07, 3 and 2, 4 in 2002. He had adjudication time serves on several misdemeanors. We would be asking for a bond. This is, he held the knife to someone's throat.
Want to give me a clue on what kind of?
I'm sorry, $3,000.
All right, with regards to count 1, bond is set at $2,500. Counts 2, 3, 4, and 5 each counted, bond is set at $100, and I am appointing counsel on counts 2, 3, 4, and 5.
Thank you. One further request, Your Honor. Mr. Lawrence is 53 years old. He does have blood clot and physical ailments, Your Honor. Would you sign an order having him medically screened?
Yes.
Thank you very much, Your Honor. Okay.
Your Honor, if I may, I know that you already set the bond in Deshaun Murphy's case. I just wanted to mention that he does have extensive priors. He has a battery, a felony battery with priors where he
Okay,
served.
you need to wait because that's not even the last one I did, so
I'm sorry, Your Honor.
go back to that paperwork.
Okay, I'm sorry. Let me know whenever the clerk's ready.
Okay, I have.
In 2010, he had a felony battery where he served 364 days and he was given 3.5.
You know what? He's gone.
I know, Your Honor.
I mean, without him here to tell me things, you can't do that. He has a right to be present, and this is the fellow that I set bond. I set 2 bonds of $10,000, and I set another one at $1,000. so he needs to be present. You need to bring that to my attention when you're before the court.
Yes, Your Honor.
Thank you.
Okay, Irvin Packer.
Mr. Packer, come on up.
Good morning, Mr. Packer. You're before the court, charged with 2 counts, and both of them are violation of probation on 2 separate cases. I do find probable cause, and you are to be held no bond until you go before Judge Mulder.
Thank you, Your Honor.
Real.
Thomas,
Ready,
please.
ready.
Hey, Thomas.
Mr.
How you doing, Your Honor?
You're before the court charged with 2 counts, sir. Count 1 is petty theft, first degree. Count 2 is a violation of probation or community control. I have reviewed the probable cause affidavit, and I do find probable cause. Your bond is set as follows. With regards to count 1, $100. With regards to count 2, you're to be held no bond until you're brought before your assigned judge. Dwayne Donaldson.
He's here present.
Mr. Donaldson, you're before the court charged with 1 count of aggravated assault with a firearm. I have reviewed the probable cause affidavit. I do find probable cause.
Your Honor, Mr. Donaldson did advise me he's been residing in South Florida for the past 8 years. He takes care of his 2 children. He has no money in the bank and no property. We'd be asking you to set a reasonable bond.
What's the state's position?
Your Honor, it looks like an open battery from 2014, December of 2014. He has in 2011 uttered a forged instrument where he served 364 days, and it looks like an adjudication time served on a resisting without. We'd be asking for at least a $5,000 bond.
Court finds probable cause. Did you say there's an open case?
I show that there's a misdemeanor battery. Let me check and see if it's still, it looks like it's still open.
Is it a domestic battery?
All I see is that it's a battery from December 12th of 2014. Looks like he was given probation 6 months starting April of this year, so this would violate his probation, Your Honor.
Anything else you want to say?
No, Your Honor, I would just be asking for a bond.
3,500. And if I didn't say so before, I do find probable cause.
Thank you, Your Honor.
Dimitri Joyner Jordan.
Mr. Joyner.
Mr. Joyner, you're before the court on 1 count of violation of probation. I have reviewed the probable cause affidavit. I also reviewed the warrant that was signed by Judge James, and I find probable cause. You are to be held no bond, sir, until you go before Judge James. Francisco Ventura.
Yeah?
Probation. You run the second check.
North Broward?
Thank you. Mr. Ventura?
Yes, ma'am.
Good morning. You're before the court charged with 6 counts.
Julio
Count
Cesar
1 is
Ramos.
leaving the scene of a crash involving damage to property. Count 2 is driving while under the influence, first offense. Count 2
Julio.
is driving while under the influence with damage to property or person of another. Count 4 is driving while under the influence with damage to property or person of another. Count 5 is violating your probation or community control, and that's 2 counts, count 5 and count 6.
Sign what you need and fun. You do it twice, okay?
I have reviewed your,
Yeah, I was supposed to go to be at my little brother's graduation today. I was on the way to the airport.
What's your name?
Frederick.
and
And
said as follows.
wanted to look nice and didn't have any money, so I stole
Good
some
luck.
clothes.
Good sign.
ROR, count 2, $500, count 3, $1,000, count 4, $1,000, and you are to be held no bond on each count 5 and count 6. Frederick Klein.
He's here at Maine, Your Honor.
Mr. Klein, you're before the court charged with 4 counts. Count 1 is petty theft, 2nd degree. Count 2 is possession of MDMA. Count 3 is possession of a controlled substance without a prescription. Count 4 is possession of cannabis, 20 grams or less. Does the defense have anything they want to say?
Your Honor, Mr. Klein did advise me he's been in South Florida for the past 5 years. He does have a place to stay. He has no money in the bank. He's financially indigent. Would you consider pretrial release for Mr. Klein?
Does the defense have anything they want to say on probable cause?
Looks like the ecstasy pills are filled with
No. Here. Initial. The medical disclosure. Are you working with it?
Okay.
Your Honor, we would ask for time to perfect on the pills.
Okay, and that's count 2 and 3.
Yes, Your Honor, 48 hours, please.
Okay. All right, sir, with regards to count 1 and count 4, I do find probable cause, and your bond is set on count 1 at $25, and on count 4 at $100. On counts 2 and 3, I am giving the state 48 hours to perfect, and bond remains on each of those at $1,000. Thank you. Vincent Moody. Mr. Moody, you're before the court charged with 2 counts. Count 1 is burglary of an unoccupied dwelling, and count 2 is grand theft.
Good luck.
I'm looking at a capias on the underlying charge of burglary of a dwelling. probable cause affidavit, your bond, I find probable cause, your bond is set as follows. On the burglary of the unoccupied dwelling, no bond, and on grand theft, $1,000.
Your Honor, on the burglary, he missed a court date, correct?
No,
Or what's...
something that I don't do, man.
I'm trying to understand why on a burglary of a dwelling, he would be no bond. Unless he missed a court date.
It was a non-custody capias, Your Honor.
That's right. It was a not in custody capias is what this reads.
Okay, but if it was a not in custody capias, Your Honor, on a burglary of a dwelling, second degree felony, he would still be entitled to a bond then.
Okay, he needs to go before Judge Rosenthal. Whoever the assigned judge is on that.
Your Honor, would you consider putting this in front of Hurley tomorrow?
That's fine.
Thank you, Your Honor.
LaShawn Spriggs.
Mr. Spriggs.
Mr. Spriggs, you're before the court on 3 counts. Count 1 is grand theft auto. Count 2 is unlawful possession of personal ID of another, and it's 5 or more. And count 3 is a habeas. The underlying charge is operating without a valid driver's license. I do find probable cause. Your bond is set as follows. Count 1, $1,000. Count 2, $1,000. Count 3, $500.
Thank you. All right, you're done.
Denaris Hall.
Mr. Hall?
Mr. Hall, you're before the court on 4 counts. Count 1 is grand theft. Count 2 is attempted escape. Count 3 is resisting without violence. And count 4 is resisting without violence.
Your Honor, regarding count 2, he's been in South Florida his whole life. He's indigent, he's unemployed. I'd ask you to consider setting a reasonable bond, Your Honor.
Your Honor, in terms of priors, he has a grand theft from earlier. This actually, it looks like May 26th. That is open and pending.
May 26th of this year?
Yes, Your Honor.
Okay.
2012 delivery of cocaine. He served 20.4 months. 2011 delivery of counterfeit substance and DWLS habitual offender. He served 20.4 months. 2011, it looks like it was a concurrent 24 months on another DWLS habitual offender, possession of cannabis, adjudication time served in 2012, and also in 2012 resisting without adjudication time served.
Thank you. Having found probable cause, bond is set as follows. Count 1, $1,000. Count 2, $5,000. Count 3, $100. Count 4, $100. Thank you. Juan Luis Benitez.
North Broward.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Benitez. Mr. Benitez, you are charged with 2 counts. Count 1 is disorderly conduct.
What was that?
Disorderly conduct. the probable cause. Affidavit. And the court does find probable cause. Bond is set as follows. Use ROR on count 1, and bond is set at $3,500 on count 2.
Your Honor, considering count 2 is third-degree felony
Your Honor?
ROR, would you consider pretrial release for count 2?
I did consider pretrial release, and bond remains at $3,500. Thank you.
Thank you, ma'am.
Julio Ramos.
Mr. Ramos, Julio Ramos, come on up. He's here present at Maine, Your Honor.
Okay, Mr. Ramos, for the court, there are 2 counts. Count 1 is a habeas. Count 2 is a violation of probation. I do have before me a habeas from Judge Tobin Singer.
31.
Yeah, he won.
And it was, I think the underlying crime was possession of PDP. The violation of probation is underlying charge of operating without a valid driver's license. I do find probable cause with regards to each count. On count 1, you are to be held no bond until you're taken to your assigned judge. On count 2, bond is set at $1,000.
I see your judge June 10th at 2 p.m. Okay, you're done.
Denmark Thomas.
Mr. Thomas? You'll be seeing your judge June 10th, 8:30.
6 counts. Count 1 is possession with intent to sell, manufacture, deliver heroin within 1,000 feet of a protected area. Count 2 is possession with intent to sell, manufacture, deliver cocaine within 1,000 feet of a special area. Count 3 is reckless driving. Count 4 is reside in I guess 4 is the sunscreen. Is that the darkness of? Yeah. Okay.
Oh, like the tint?
The
I think,
tint, right.
okay.
Count 4 is a charge on the sunscreen or the tint of your vehicle. Count 5 is violating probation or community control. Count 6 is the same, violating probation or community control. Each of those are on separate cases. I have reviewed the probable cause affidavit, and I do find probable cause. I also have show the violation of probation community control, and you are to be held no bond on that. So your bond is set as follows. Count 1, $7,500. Count 2, $7,500. Count 3, $100. Count 4, ROR. Count 5, no bond. And count 6, no bond.
Thank you. Okay.
Thank you. Karen, Desiree?
I've been advised, Your Honor, Mr. Desiree bonded. Thanks. What's your name?
The professional.
probable cause. Lakeith White.
Paul Ryan, Your Honor.
Thank you.
You're welcome.
How you doing, Your Honor?
Good morning, Mr. White, here before the court on added charges, and it would constitute count 6, 7, 8, and 9. Those added charges are all capiouses. 6 is felony possession of cocaine with intent to sell or distribute. Number 7 is felony possession of hypersaline. Count 8 is possession of cannabis with an intent to sell or deliver. Count 9 is possession of alprazolam. I do find probable cause. Your bond is set as follows. Count 6, $3,500. Count 7, $3,500. Count 8, $1,000. Count 9, $1,000.
Your Honor, can I ask you a question?
You may.
I paid the bond for this in July. Will I have to repay that bond?
You're going to have to talk to your lawyer, sir.
Thank you.
Okay, you're welcome. Anthony Piergrossi?
North Broward?
Yes, Judge.
Mr. Piergrossi, you're before the court charged with 3 counts. Count 1 is petty theft, second degree. There's another petty theft, second degree, which is count 2. And count 3 is criminal mischief, over $1,000. I have reviewed the probable cause affidavit. I do find probable cause. Your bond is set as follows. You're released on your own recognizance on count 1 and 2. And on count 3, I'm setting a bond of $500.
Judge,
Yes.
as a lifetime resident, never missed a court date, would ROR on the third count be a possibility?
Does he have any brothers?
Your Honor, in 2013, he has a burglary structure unoccupied. He served 16.5 months and a adjudication time served on another petty theft. 2007, 2 counts of dealing in stolen property, burg, conveyance, unoccupied, and a grand theft where he did 29 months. 2007 grand theft auto where he served 31 months on a VOP. Everything else is 2002 or older.
Thank you. Mr. Piergrossi, the bond remains on count 3 at $500.
Thank you, Judge.
Thank you. Jerry Exum.
Paul Ryan, Your Honor.
Thank you.
You're welcome.
Mr. Exum.
Good morning.
Good morning, sir. Sir, you're before the court on 1 count. It's a capious, and the underlying charges are armed kidnapping, burglary of a dwelling, armed, and robbery with a firearm. I do find probable cause. The one before me today is the 3rd count. You are to be held. No bond until you go before your assigned judge.
You have discretion because these are act counts that change the charge. You set a bond in the case.
Thank you. I understand that. He needs to go before his assigned judge. There's not enough information before me to change what's here. Okay. That's it for my paperwork. Okay.
There's one more. Come on.
All right. I've been given Louis Jacob Peterson.
Yes, Your Honor.
He's here at Maine, Your Honor.
Thank you. All right. Let me read this since it was just handed to me.
He was the one that had the full bench this
Okay. What's the state's position?
Your Honor, there's no additional information. Judge Marks already found probable cause for a trespass and set the bond at $2,500.
Well, actually, I'm looking at the evidence. The order from Judge Marks doesn't find probable cause, but I do find probable cause for a trespass, and I will leave the bond at $2,500. I need an order. I need an order.
Your Honor, having found no probable cause, and the judge yesterday found no probable cause as well. So now we're down to a trespass. Basically, Mr. Cruzen is 21 years old. He has a place to stay I believe he has no prior contact with the system. Considering this is a misdemeanor, Your Honor, would you consider $100 bond?
You guys put them on there already?
No.
What's the statement?
Your Honor, give me just a second. I had to close the safe out. This is the same incident where the 66-year-old owner of the home was attacked when he tried to confront the two defendants that were in his carport.
Allegedly by the other defendant, correct?
Yes, and this person was with him. So, Your Honor, I'd ask for the $2,500 bond.
Does he have any priors?
I don't show any.
Okay. I do find probable cause on the trespass. Bond is set at $1,000, and I need an order. Okay, because this order doesn't, it's signed by Judge Mark, but it doesn't show probable cause and it doesn't show trespass.
Basically, probable cause was found as a trespass, and bond is set at $1,000.
As of yesterday, Judge, he gave him a bond of $2,500, but he found no PC. So today, if you're,
I'm finding trespass and I'm giving him a bond of $1,000.
okay, this should stand. It's the new.
Oh, you've got one?
Yeah.
Okay, perfect. We got one. I just didn't have it here.
Yeah.
Okay, so I do find probable cause as to trespass. And I'm setting a bond of $1,000. Okay, are we done?
Yes, Your Honor.
All right, well, thank you, everyone.
Thank you.
Thank you, you as well.
Thank you, Your Honor.
You're welcome, sir. Have a good rest of the weekend. And however this thing is turned off, I don't know how to do it, so. You're welcome. Want this back? There's goes in her order.
Here's your pen back.
Thank you.
The second page, so. You're welcome.
You might have had a bond, but it's probably just if you needed it.
No, it said no bond.
Okay.
Okay, have a good one, everyone.
Have a good weekend, Your Honor.
Yeah.
Excuse me? Elizabeth Rodriguez, Elisabeth. And he's Jonathan Moorheim. Moorheim, how do you spell your last name?
M-O-R-H-A-I-M. See you later.
Take care, guys. I can't find it now.
For the best.
No, I'm really upset about that. Oh, this one. It said no bond because it's a first-degree felony, home invasion without firearm or weapon, a battery, and then wearing a mask while committing a second-degree felony.
That could be fine.
Knock the victim's door, open the door, because it wasn't armed. That's the only. I think if it was armed, that might be a PBL, but I think this is just. I don't think this is. But yes, I do. Is this the one that the email was about?
Have a good weekend.
No.
No. Okay.
No, that was...
Because I was like, because I saw Viper unit, so I was like, oh shit.
No, the Viper unit was...
McLean.
Jacobs.
No.
Sean Jacobs.
Dwayne.
Dwayne.
Dwayne McLean.
Who the fuck is that? Wasn't Dwayne McLean up today? Didn't we laugh because his name went in?
Yeah, he was.
Where was he held? He was like towards the middle.
Do you have where'd you put the
Terrible with names.
juvenile packets?
Right here.
Okay.
Oh, you wanted me to keep those? I threw them out.
I mean, yeah, keep them. Give them to Jackie because she scans. Oh.
Bye. That was a lot less painful than yesterday.
Really? It's only because you were in that seat.
That's true. That was insane. At least we got out pretty good today, yesterday. Better. Could have been worse. All I'm saying.
This is the one that he had one.
It was him, right?
He wasn't held no bond, but he has.
He has like $1 million bond.
100. Like over $100,000 worth of bond.
Right.
So he's with $10,000 in cash,
Right.
or $100,000 worth of over $100,000 worth of collateral.
Yeah, and I think he just wanted to revoke in the other case. That's what the guy was asking for. And what he said wasn't, please make sure he gets revoked. It was, it would be nice if you could revoke. So we're, come on. Should've got it for you.
Yeah. Okay. Let me close everything down.